Hey everybody, it's Kathy. I'm so sorry for the glitch that occurred today with respect to the live that we were supposed to have. There was a technical problem that I just could not fix, and rather than have you guys stand by, I know there were a few people that were waiting, and I really am so sorry to have disappointed you and to have wasted your time. I decided to go ahead and cancel, and we'll go ahead and hopefully be able to reset it when I can figure out or get someone to help me figure out what this glitch is. But in the meantime, as I do have access to video, I decided to instead provide you with some thoughts regarding this really important week in the Idaho versus Kohberger case that so many people are interested in. Just by way of background, if you're new to the case started with some very tragic events back on November 13th, 2022, when 4 students of the University of Idaho were found unalived in what appears to have been, from all accounts, a tremendously tragic and horrific scene. Kaylee Goncalves, 21, Madison Mogan, 21, Xana Kernodle, 20, and Ethan Chapin, also 20, were found that day at 1122 King Road inside the home. And thereafter, there was a search for the perpetrators of these horrendous crimes. And ultimately, about 6.5 weeks later, an arrest was announced clear across the country of Brian C. Kohberger of Monroe Township, Pennsylvania. He was booked into the Monroe County Jail. He could not be sent immediately back to Idaho because of the sort of setup that we have here in our country, which is we have one federal government and then all of the states operate as their own sovereigns. So there had to be an extradition proceeding, and he did not fight it. He agreed to go back, and he went back about a week later to face charges in Latah County, Idaho, and the case has been proceeding ever since then. This past week was a really big week. I think the most significant week in the entire case to date. There were a number of hearings that had been scheduled back on October 9th by the Honorable Stephen J. Hippler, who is presiding and has been presiding over the case since the change of venue from Latah to Ada County occurred in September of 2024. Judge Hippler put out a pretrial and trial order, and I do recommend that if you're new to the case, and even if you're not, if you're a veteran who's been following, researching the case, if you're a fellow journalist, podcaster, citizen just interested in trying to find out what happened and ensure that justice is served for these 4 young people who were so tragically lost, I do recommend that you review Judge Hippler's pretrial and trial order of the 9th of October, because it really does provide the blueprint for the rest of the proceedings leading up to voir dire, which is scheduled for the end of July 30th, 2025, pursuant to that trial order. If you go to page 2 of that trial order, you'll see that there are a number of pretrial matters. The matter of, under paragraph B, top of page 2, the DP motions that the defense filed in hoping to strike the DP. Those matters have all been resolved, and Judge Hippler has denied all of the various motions to strike the DP. So this remains a capital case. Mr. Kohberger, of course, under our system of government, is considered innocent at every stage of the proceeding until such time that he is either adjudicated or he pleads guilty. So with respect to that pretrial and trial order, the next paragraph, actually the next 2, deal with discovery-related matters and Rule 12 matters, including motions to suppress. Those matters were scheduled for January 23rd and, if necessary, for the 24th by Judge Hippler back in October. As it turned out, the matters, because there were so many, there was 13 motions to suppress, a motion to compel, and then also a motion for a Franks hearing that we're going to talk about in just a second. So I'm recording this on the afternoon of the 25th Eastern Standard Time. This past week, all of these motions, and these were all defense motions, there was no state of Idaho motion that was scheduled for the 23rd or the 24th. These were strictly the moving party, being the defense, Mr. Kohberger in this case. But before those hearings happened, there was a really big development, in my opinion, which saw the return of the former interveners, the Media Coalition. If you've been following the case, you know that they did go to the Idaho Supreme Court back in 2023, hoping through either a writ of mandamus or prohibition to strike the non-dissemination order that was in place and had been in place after the parties filed a notice, a stipulation in Latah County, January 3rd, 2023, at the very beginning of the proceeding, asking the court to enter that non-dissemination gag order, call it what you will. So it's been in place in one form or another ever since then. Media Coalition went to the Idaho Supreme Court. The Idaho Supreme Court made basically two rulings. It's called the AP, Associated Press et al., meaning there's additional parties, there's other members of the media, versus Second Judicial Circuit in Latah County. And in that case, what the Media Coalition was looking to do was to have the Supreme Court reach down to Latah County and to order that to actually strike and to prevent that proceeding, Idaho versus Kohberger, continuing with that gag order in place. The Media Coalition was unsuccessful with respect to that, but I believe that the Supreme Court of Idaho made a very important finding and an important ruling that you've heard this week if you've watched any of the proceedings. The Idaho Supreme Court found that the Media Coalition indeed had standing. And what standing is if you want to get involved in a case like this, Idaho versus Kohberger, you have to be able to show that you have a legal right to do anything, to be heard, that you have a present or an imminent injury, and that you seek relief for it. You have a stake in the action, if you will. So they did convince the Idaho Supreme Court that there was a stake in the action. And after the Supreme Court of Idaho ruling came down, what the court also said was that we're a court of last resort. You don't come here, you really need to go to Latah County and plead your case there. And if you're not satisfied and you feel you have legal grounds, then come back to us. The Media Coalition did make an appearance as interveners or proposed potential interveners in this case. And by this case, I mean the state of Idaho versus Brian C. Kohberger when it was still in Latah County. And they made their pitch that the gag order should be set aside. John Judge, who was the presiding jurist at that time prior to change of venue, denied that motion. And then they came back again when there was some potential for having all cameras banned from the courtroom while it was in Latah County. And they made a pitch against that happening. Judge denied removing all cameras. What he did is he did kick out the media themselves. And from that point on, and this is 2023, summer of 2023 when this happened, you've only seen the camera from the courts themselves. First it was in Latah County, and now it's Ada County, the 2nd Judicial District versus the 4th Judicial District. So we really haven't heard anything from them in a while. And then all of a sudden, they did file 2 sets of documents this past week, one on the 21st and then a second on the 23rd. The one on the 21st was filed shortly before the defense, the state, and the court, plus Mr. Kohberger, were called into a virtual hearing, 10 a.m. on the 21st, to decide if these hearings that had been pending for a couple of months on the 23rd and the 24th would be public, private, closed, and also to entertain Mr. Kohberger's motion to have the briefings. And when you hear briefings, that's motion on the part of the moving party, response and opposition to the moving party's motion, and then reply responding to the other side's response. In this case, it was a motion to suppress IGG evidence. They wanted the briefings that have been under seal open to the public, and they also wanted the hearing related to their motion to suppress IGG held as a public offering. Judge Hippler denied the media coalitions, and they came back this time as interested parties. They pulled, I thought, a really boss move, if you ask me. What they did is they used some language from the Associated Press versus Second Judicial District from a couple of years ago, where the Supreme Court found that they were interested parties, the media was interested parties under the First Amendment that did have a stake in the action. So they came back this time not as interveners or proposed interveners, but interested parties who wanted to be heard. And there was one other change this time around. It's not Associated Press anymore as the lead party. It is now ABC is the lead party, and then Associated Press. So you see a slight change. It's still the same organizations. It's the coalition of various local, statewide, and national media organizations that have come back. They filed a motion to be heard as interested parties on the 21st. They filed that paperwork shortly before the hearing was scheduled to be entertained by Judge Stephen Hippler. Judge Hippler decided that it was too late. It was an untimely filing. There was notice that this hearing was going to happen from the 15th, and I agree with the court. I think that there was no reason, at least in my opinion, that the Media Coalition could not have filed at least a motion and then followed it up with their memorandum of law on the 15th or the 16th, at least a week before. But in any event, Judge Hippler did deny that motion to be heard, and he did file a document, an order on the docket. You can read what the court's finding was. It was basically that it was just untimely. Well, what the Media Coalition wound up doing is they filed a renewed motion to be heard, and that was filed the morning of the 22nd. And that document is also in the public docket. And they said, look, per the First Amendment, we should be there, we should be heard. We believe that these hearings should be open, that these filings should be public. You took no findings of fact, Judge, to find out that Mr. Kohberger's rights would be harmed if this was broadcast, and if we, the press, were able to do our job and be able to report on this immensely important case that has garnered so much attention, and so on and so forth. And they talked also about this Franks hearing, that the court was scheduled to take evidence and testimony, and that's exactly what the notices said last week, that this was going to happen in closed session, that there would be a hearing on the motion to suppress relative to the IGG materials, that Mr. Kohberger was wanted suppressed from the case, but also that live testimony, live evidence was going to be taken relative to the Franks hearing. And the Media Coalition on page 3 of their renewed motion went into some detail as to what Franks is, why it was important for them to be there, and at least to be heard. So that was followed by a notice of hearing for the 22nd at 3 p.m. Judge Hippler held a hearing on the renewed motion to give them an opportunity to be heard. Wendy Olson, lead counsel for the Media Coalition, same attorney who represented them before the Idaho Supreme Court and also in Latah County, was given an opportunity to be heard, and she made her pitch why she felt that the hearings needed to be public. Judge Hippler denied that request in terms of opening up the IGG motion to suppress hearing and also the live testimony that was being taken going to the Franks motion. So at this point, it remains to be seen if the Media Coalition is going to do anything further, if they're going to go back to the Idaho Supreme Court and demand that the transcript, perhaps, from the hearings that happened the 23rd, when they started at 9 o'clock a.m., there is a transcript of that event. We certainly can't go back in time and have that hearing happen again, but at least there's a transcript. And then there's also, I wondered in the back of my mind, I wondered if it was taped. They have the video capacity to tape these things and to live stream them. So I'm wondering if it was taped, if it was videotaped by the courts and just not live streamed. So it remains to be seen if the Media Coalition will do anything or if they're just going to let things lie at this point. But that was one of the significant events of the past week that I'm going to continue to keep my eye on for you here at the Indie Zone, both on the podcast and YouTube, and report back to you as things happen. And I just wanted to give a little bit of a introduction to myself. I've got a lot of great followers that from all different points of life. Some are truck drivers, some are nurses, some are teachers, bookkeepers, work in restaurants, chefs, and we all are trained in a specific area. And I've certainly benefited when people who are trained in areas that I'm not trained in will share their knowledge and their experiences with me. Been to law school, so I sort of know how filings work and how they operate. And so I really focus on the filings. And I think it's important to be able to help anyone who thinks that my content is valuable to understand what is voir dire. You know, the first time I heard it, I'm sitting my first semester of law school having a cup of coffee with some upper class students, and they threw out voir dire. And, oh, yeah, voir dire, voir dire. I didn't know what it meant. I had to go look it up. You know, and it's, of course, it's the process of jury selection, which will happen in this case on July 30th. So we all have our experiences that we bring to the table, and I do hope that you will appreciate the point of view that I'm trying to bring and find some help and some assistance as you're going through and trying to understand this case. I think it's really imperative to know what the filings say. And my biggest concern about this case is the number of filings that are under seal on top of the gag order. We still don't know what a lot of the evidence is in this case, what this case is really all about. We started to get a little bit of information in the past couple of days. I think possibly if you watched the public portion of the hearings on the suppression motions, the one discovery motion to compel, and the matters related to Frank's, you'll appreciate that we haven't had some of this information brought out into the public before. And which then leads me on to, I've been asked, what did I think of this past couple of days performance? And, you know, Judge Hippler made no rulings on the record, although I think that we got some clues as to how he may be leaning. And what I wanted to do is to kind of revisit what the Fourth Amendment says, because all of these matters that you heard, with the exception of the motion to compel, because that has to do with discovery, the suppression motions, and also this prospective Frank's hearing that Mr. Kohberger is wanting, everything relates back to the Fourth Amendment. The suppression motion deals with suppressing, meaning having evidence thrown out as it relates to an argument that it's the product of an illegal search or seizure under the Fourth Amendment. You'll also see the Idaho Constitution quoted as well in these filings, but the Idaho Constitution that bars unreasonable searches and seizure, just like most of the states, is modeled after the Fourth Amendment to the U.S. Constitution. A Frank's hearing is something completely different. It attacks the validity of the affidavit leading to some type of a warrant. We'll get to that in just a second, but I want to just go over what the Fourth Amendment says. It tells us that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation in particularity, describing the place to be searched and the persons or things to be seized. So there's a couple of points that I just wanted to stress about the Fourth Amendment. 4 categories the framers of our Constitution included in here. Free to be secure in persons, that means our physical beings. Houses, whatever our house is, it's a mobile home, it could be a townhome, it could be a magnificent mansion somewhere overlooking the ocean, it could be a house, middle-class neighborhood, it could be in a condominium or an apartment. These are all homes. These are considered houses for purposes of the Fourth Amendment. Papers and effects, and those 2 categories have been expanded to include a lot of different things. But there needs to be standing to be able to raise a Fourth Amendment issue in terms of an illegal search or seizure. You have to have standing. And Judge Hippler talked about it. And if you want to, know what standing is a little bit more, look at the case that the interveners brought to the Idaho Supreme Court, because the Idaho Supreme Court did talk about what standing is. It's an immediate stake in the action where you have a potential immediate injury. You have to have some reason for being there under the eyes of the law in front of the court. The other thing that I wanted to point out is unreasonable searches and seizures. So searches and seizures are by the government. This is again by the government. This is not a private party. This is the government. This could be state government. It could be federal government. At first, the Fourth Amendment was just the federal government, but it was made applicable to the state under the 14th Amendment due process clause. That's why you see the 14th Amendment a lot of times. Even in the Jerome Franks case, the 14th Amendment is discussed as it relates to the Fourth Amendment. The 14th Amendment due process clause is what makes the Fourth Amendment applicable to the state. So again, this is government action only. But upon probable cause, there must be probable cause supported by oath or affirmations by law enforcement and particularity. It can't be specific. It can't be a general search of a person's entire house if the weapon that law enforcement believed was used in an unaliving crime is in a closet basement. Can't go through the entire person's house, through their things, through their personal effects. So those are the key points to know about the Fourth Amendment. Sometimes people think it means more than what it does, and sometimes people think it means less than what it does, depending on where you are. The other thing that I wanted to point out is Judge Hippler, sometimes when you see him talking, he'll ask, like he did ask Ms. Taylor one time, he said, "What's the citation for the case?" And she said, "Oh, I have the case name." "What's the citation?" The citation is the reporter and the page number where court filings are found, such as rulings, such as precedent, and we're all about precedent in the United States. That's why you see Judge Hippler asking, do you have a case? What's your case? Or if you look at the memorandums of law, you'll see a bunch of case citations to the U.S. Supreme Court if it's a Fourth Amendment case, and a lot of times to the Idaho Supreme Court. The case of Jerome Franks versus Delaware is if Judge Hippler was to ask someone who's in front of him, give me the case citation, you would not only say, okay, what's the Franks case, Franks versus Delaware, that's the title, but the citation is 438 U.S. 154, 1978. That tells us the page number and the volume of the reporter of the United States Supreme Court's opinions and their rulings and findings. And 1978 means the year that it was rendered. This is a case from June 26th, specifically, is when the opinion was rendered in 1978. And Franks, a lot of people think it means more. Some people think it means not less. I'll read exactly what someone needs to show to qualify for a Franks hearing, and it is very difficult. Franks hearings are rarely granted, and because there's a high burden of proof that a defendant must show because they're attacking the warrant affidavit, which, number one, a warrant issued by a judge or a magistrate is presumed correct. So they have to come over that burden, and then they have to pass every element of this Franks test, and it comes directly from the case law. And if you look at it, the holding is where a defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit, and if the allegedly false statement is necessary to a finding of probable cause, the Fourth Amendment, which we just read to you, as incorporated in the 14th Amendment, that's the due process clause, requires that a hearing be held at the defendant's request. The trial court is therefore, in this case, made a mistake in refusing to examine the adequacy of petitioner's proffer of misrepresentation in the warrant affidavit. So what happened is that Jerome Franks was arrested for a terrible crime that the government felt that he was responsible for, and there were found to be some misrepresentations about what his employer said or didn't say to law enforcement that they proffered to get the search warrant from the magistrate, and the courts in Delaware would not allow him to be heard as to this issue. So the Supreme Court, in interpreting the Fourth Amendment, found that if a defendant is able to meet this burden, this very high burden of proof, then he is entitled to a hearing, which is why my confusion came into play this past week, because Judge Hippler wrote in his order that he was going to be taking testimony. There was going to be testimony going not just to the suppression motion, but to the Franks hearing that the defense was asking for. And it was also brought up by the media coalition as well. If you look at the renewed motion to be heard, then they both address the obvious. And then I was quite surprised to see at the end of the hearing on the 24th that Judge Hippler, on the record, with the world watching and so many people watching, asked both sides, look, I don't know if I'm going to be granting this Franks hearing or not, but give me some dates of availability within the next 3 weeks. He did not have to do that. The way that things usually work is a judicial assistant will reach out to the attorneys. You don't have the judge doing it from the stand usually, especially in a high-profile televised case where so many eyes and ears are going to be seeing and hearing that. But in any event, then it says here, to mandate an evidentiary hearing, the challenger's attack must be more than just conclusory. You just can't say, oh, well, this warrant has these, fabricated statements. It's intentional, it's knowing, it's with reckless disregard for the truth. No, you have to pinpoint to the record. And you'll know if you have been listening to the Indie Zone, and I want to go ahead and pitch the podcast for you. There's 5-minute or less episodes on all of the filings in the case. And it's recently been populated onto YouTube, so you can just go to the part of the YouTube channel that talks about the podcast. And we've had several episodes dealing with what the burden of proof is for a Franks hearing, and it is very, very high. You have to be able to pinpoint to the record, and you know that if you've been listening to the podcast. Back on November 22nd, Judge Hippler basically said to the defense, this Franks motion for a Franks hearing and memorandum in support is not acceptable because it didn't pinpoint to the record the evidence that they wanted the court to look at, and it comes directly from the Supreme Court's ruling. Can't be conclusory. It can't just be, hey, I don't like this person. They're obviously out to get Mr. Kohberger. No. You have to pinpoint to the record. And there were also some other problems. It was something like 2,000 pages, and there were repetitive documents. Read the court order and you'll see it. But that's what, and Judge Hippler also from the bench the past couple of days, I think he said once or twice, where on the record do you want me to look? Where on the record you've got to pinpoint. If it's deposition testimony, you need to say, deposition of such and such, page 12, lines 1 through 15. Or if it's a discovery, the investigator's report of when he spoke with such and so witness, page number 6 of the first contact, which occurred November 30th, 2022, at pages 2 and 3, Your Honor. That's what I'm pinpointing to the record to, the information in support of the tremendous proffer. It has to be a substantial proffer in order to even qualify for that Franks hearing. So in terms of what my person, we all give our opinions. My opinion is no better or worse than anyone out there. As a matter of fact, the only person's opinion at this point is Judge Stephen Hippler, because he's going to either grant or deny these motions that are currently pending before him, because everything's done. The briefings are closed, oral argument has happened, presentation of evidence occurred. Now it's just down to the rulings. So it's really just his opinion that matters at this time. But in going to what I saw, I was a little surprised that the defense just appeared to me, and I give my opinion, that they were not as prepared as maybe they could have been for such an important hearing, especially the Franks hearing, the motion to suppress IGG. That's really been a priority for the defense. That's their strategy. And when we finally went on to the open session, it was the afternoon of Thursday, the 23rd, the first day. And I say when finally, 2 hours behind Ada County from the East Coast. And when you have witnesses on the stand, you just don't know. You think you're only going to need them on the stand to ask a couple of questions, 20 minutes to verify something. They can get on there and give an answer that then you now need to ask 10 follow-up questions. So it really wasn't long, and we don't even know how many witnesses were there that morning because, of course, the witness lists are also under seal. But this hearing was noticed back on October 9th. 2024. And usually when you have a hearing before a court, you're going to bring in a binder, you're going to bring in pinpoint things, you're going to have post-it notes, you're going to have all of your materials there, because the most important thing that you're there for when you're giving oral argument, after all of the memorandums of law, the motions and the supporting information has been in, especially for someone like Judge Hippler, and we found out now he has a staff attorney who's reading these also with him, that you have to be ready to answer the court's questions. You got to anticipate what the court's question is. And one of the court's questions that I think all of us saw coming was the issue of standing. What standing did Mr. Kohberger have to raise? And again, this is a Fourth Amendment. This is an expectation of privacy as to my persons, my house, my effects, my things. I can't raise my next door neighbor's expectation of privacy if their house gets raided and the blinking lights are coming in my house and they're bothering me. No, that's their expectation of privacy in their home under the Fourth Amendment. So I think that in the response, and we had Mr. Nye get up and he said, you could sit here all day long talking about policies and procedures and how they're not followed. The Supreme Court has stated that violation of a policy and procedure by Othram, by the feds, by whomever, does not make a Fourth Amendment violation. You need to show the court how it is that Mr. Kohberger has a privacy interest in some type of it sounds like a family member, maybe a distant family member. We don't know because all the people in the family tree from the IgG testing have been deemed as confidential informants. Informants maybe not in the traditional sense, but informants nonetheless. Please, if you haven't had an opportunity, read the October 2023 order that Judge put out, because he went into length about IgG, the case law, that it's new, that it's emerging, that this was a case of first impression for him because there wasn't a lot of precedent. When I said before, you usually look to see, how does the higher court rule? Has a matter like this ever come before the Idaho Supreme Court or an Idaho appellate court or the U.S. Supreme Court if we're talking about the Fourth Amendment, because the U.S. Supreme Court has the final jurisdiction and authority to determine what the Fourth Amendment says or doesn't say. So he made a valid point. It seems like from what Judge Hippler was saying, this was in their proffer. So this was in their briefing that they raised standing as an issue. So with that said, I would have thought that the reply memorandum would have addressed standing if that's what the other side, because remember, it's motion application for a suppression, an order suppressing IgG DNA evidence. Then the other side responds in opposition, and now we got a clue directly from Judge Hippler and from Mr. Nye for the state of Idaho in his response that their opposition motion raised standing. And I would have imagined that the reply brief would have said, no, Mr. Kohberger does have standing. He's wrong. They're wrong. This is the correct. And, at one point she made a comment that, everyone's DNA would then be susceptible for police investigation without a warrant. And Judge Hippler said words to the effect of, okay, Ms. Taylor, do you have a case that stands for that proposition? And what she said was, no, but I also don't have a case that stands for the opposite. And what might have been said instead, and I give my opinion. I'm not an Idaho licensed attorney. I'm a citizen and a podcaster, and I say maybe the thing to say was, this is a case of first impression, Judge, so you're going to have to make this ruling. But it still doesn't get you around standing, but it's an argument as, well, no, I don't have case law, but there's no case law on the other side as well on this particular issue. So I was a little surprised at that. I thought also that they were unprepared because Judge Hippler was ready to work on the Franks motion, first issue, when it went from closed into open session, and defense counsel thought that she was prepared for the Franks hearing. Well, having done these a couple in my past life, you go and you ask, you find out, which the court did put out a schedule of what the motions were in the DP motions. If you take a look at that, prior to the hearings on the motions to strike DP, he did have out, okay, this is what we're going to be at 9 o'clock. This is 9:20. This is 9:40. And it's 20 minutes total, not 20 minutes per side. So knowing that just coming out of somebody couldn't have asked the judicial assistant, what's the court starting out with? And then you pull out your binder for that. I don't like to criticize, but I'm just saying this is what I might have done. Just an opinion that I'm throwing out there, and I'm throwing it out there just as I say, First Amendment, freedom of speech and of the press. The other thing is then when Judge Hippler began asking, okay, well, what about standing? What standing does your client have with respect to someone else who decides to be a purchaser of one of these tests? What standing does he have about his, whoever it was, DNA, this distant relative's DNA? And maybe the answer to give, maybe is, well, it's my DNA too, and I didn't give consent. It just something to argue standing. And again, that's an opinion. I'm not giving it as an attorney. I have no more information than just watching the events on YouTube like everyone else did. But then when the court began to, this was an important point for him. And this is your whole reason for being there, is to answer the court's question to the court's at least satisfaction, because whatever he says, he's going to either grant or he's going to deny this motion that is so important to the defense. And just kept going back to, I thought we were going to argue this other thing about policies and procedures, when, maybe that's an issue for another day, such as, this was untruthful and this was not right and everything. And there's something else, but it's not a Fourth Amendment issue without standing. So I was a little surprised. I think Mr. Nye did a really good job. He came on and he went back to standing, and it is absolutely imperative. So with that, I don't know how the court's going to rule. Maybe he'll say it's a case of first impression, now that he's, had some time to look, and he's got a staff attorney who might be doing a little bit more research on this issue. With respect to the other matters, remember when we said that the Fourth Amendment says you must show specificity. You can't go in there with a general warrant. So when we started to hear some of the argument and the supporting evidence that was addressed by counsel, that this was a real broad search of Apple, for example, that's one of the motions to suppress his Apple account. They could have kept it narrowly tailored to the 4 victims, to their inner circle, to the places that they worked, to any communications directly with them. They would have had their numbers, their past telephone numbers, anything with the University of Idaho, associates of theirs, things of that nature, and keep it narrowed. Because as I think defense counsel pointed out, Mr. Kohberger didn't have a tie to that area. He's all the way across the country in Pennsylvania, in the foothills of the Pocono Mountains, and and there was no tie, at least physically, until he moved out to Pullman in, I think it was June of 2022 or around that time. Maybe he had a couple of trips out there before to go take a look at the campus. I don't know. We don't have access to that evidence, but I think that the information should have been at least looking at the Fourth Amendment. I think that they made some really good points there. And also as it goes to the CSLI information on the phone, that was a real important method that they had to try to track the travels of suspect vehicle 1 and the 8458 phone. So I think that they have a lot. They have, they brought up some valid points, that the warrant asked for items going back to 2016, apparently, almost 7 years before he ever had any connection to even the West Coast, to Washington State University. So I think that under the Fourth Amendment, because it does say here, probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Then we had the motion to compel better answers to expert witness disclosures, and we saw what Judge Hippler's admonishment was. And if you haven't had a chance, I think that you need to go back. I think that he's expecting that when there are deadlines, that the deadlines are met, and are met in the way that the rule of procedure says, and also as his October 9th, 2024 order indicated. I checked the docket as I do the case summary page, which is the paper that the clerk of court maintains to document all of the key developments in the case from the beginning of the case. and you can go and look at this case, and I really recommend that you do, is you go to the Idaho Courts of Judicial Interest, the Idaho Courts Cases of Judicial Interest. You can find it on Google, whatever search engine, and then go down to the Kohberger case, and right under the case style, which is State of Idaho versus Brian C. Kohberger, the case number, you'll see a hot link for the case summary page. If you pull that up, there's been some entries that have not yet hit the docket, but they are PDFs, so we know that those are going to hit the docket at some point. Those, when you see the PDF icon, you know that that is a public record, versus when you see the little lock and key, that is one of the many, 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 many documents that are under seal and hearings under seal in the case. There were 3 entries: minutes, court minutes for the 23rd public, court minutes for the 23rd private, and then court minutes for the 24th public. They should be coming down the docket, I would imagine, next week sometime. When they do, I'll report back to you, but you can also take a look at them when they do come out. What the minutes do is they will memorialize who was there, when things started, what time they go off the record, who was present, what motions were discussed, and what happened. So you can also look at those. And right now we're just in a waiting mode as to, number one, is the court going to grant this Frank's hearing or not, as well as is the court going to grant or deny the motions to suppress. Now, in looking back at Frank's, I want you to bear in mind what the test is. Beyond getting past that the warrant was valid, and that's a general principle in all cases, not just in the Frank's theory, then the defendant must make a substantial preliminary showing. There needs to be a lot of evidence. It just can't be 1 or 2 little things, not particularized, not going to the record and pointing Judge Hippler exactly in the record. And now he has live testimony to add to that, showing that a false statement, knowingly and intentionally, or with reckless disregard for the truth. So 1, there has to be an intent to want to make this lie. I formulate a plan in my head. I know it's wrong, but do it anyway. That I intentionally did what I did. Versus reckless disregard. I should know better, but I'm going to give you an example. I'm really mad, at someone. Someone's really mad at someone. I want to say, someone's really mad at someone, and they decide they're going to burn down their house. They go in there to light a match, the kerosene, and the house goes down. Intentional act. Versus reckless disregard. They didn't really intend to, but they kept, the stove fire going with some gasoline right on the counter next. That's reckless disregard, and the house comes down. That's the standard. One's intentional, the other is a negligence standard, but it's so high that a person knew or should have known what they were doing was wrong. So you need to have one of those showing enough evidence to either show intent or with such reckless disregard for the truth that it meets this standard. And then, knowingly and intentionally, or with reckless disregard for the truth, was included by the affiant in the warrant affidavit. That's going to be the affidavit usually for probable cause, seeking a warrant, hence the term warrant affidavit. And if the allegedly false statement is necessary to the finding of probable cause, the 4th Amendment is incorporated, and the 14th Amendment requires that a hearing be held at the defendant's request. Really important. This few words is so important. Was necessary to the finding of probable cause. So what this tells us is there can be a knowing and intentional statement, act done, reckless disregard for the truth, but if it wasn't necessary for probable cause, it doesn't meet the Frank's test. We can sit here all day and night and debate certain things that we feel about what's been said in the case, either from the documentation or some of the live testimony that we've seen. But if it doesn't meet this test, he doesn't get a Frank's hearing, period, and no defendant does. It has to be, you can look up the case, I've provided the citation for you, where a defendant makes a substantial preliminary showing that a false statement, knowingly and intentionally or with reckless disregard for the truth, was included by the affiant in the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, the 4th Amendment is incorporated in the 14th Amendment. So at this point, I think Judge Hippler has given us some clues that he's leaning toward possibly this Frank's hearing. I did a couple of episodes of the Indie Zone. I think I've told you what they were here, just some hints. We don't know what he's thinking, what his ruling is going to be. But he also made a statement that, I think that it can't be underestimated when he said DNA on a sheath is probable cause every day of the week and twice on Sunday. So we're going to have to wait and see, as we do always, with how Judge Hippler is going to rule and where this case will go. These findings are absolutely crucial to this case. If it's in favor of the defense, it could change the rest of the case. Sometimes it leads to cases being dismissed if it's really hitting the evidence that strongly, or there could be a plea deal sometimes happens after these cases happen. If the state wins, if these hearings, if these motions are denied, then the opposite. And the state's case is all that strong. It's withstood motions to suppress and a request for a Franks hearing. So we're going to wait and see what the court rules. And when the court does, we will, of course, report back to you. And if you have any questions, any comments, any feedback, I appreciate all of your feedback. Whatever side of the fence that you're on, whether you believe that Mr. Kohberger is innocent, which he is innocent under the eyes of the law. I mean, that is absolutely in our Constitution, and we should be, I think, grateful that we have these constitutional protections of due process and everything else, because it separates us from a lot of countries that we don't want to be in. If you feel that what you've seen so far convinces you that he's innocent, if you feel the other side, if you believe that what you've seen so far shows that, the state's made a real strong case here, that, it's probably he's going to have a problem. And there may likely or possibly meet that beyond a reasonable doubt, which is a really high evidentiary standard to meet, with Judge Hippler's words about probable cause. But then Judge Hippler's words about some of the other things he said. I think that this is one of the most fascinating cases. It's a tragic case, and we always want to remember the lives that were lost, the families who were changed, the opportunities that just were expunged in a matter of moments, according to law enforcement at 1122 King Road on that very tragic Sunday. We always remember the victims, and we fight and hope for justice, and it's our part, I believe, as citizens to ensure that that happens. I want to thank you very much for joining us. We hope to do another live where I'll be able to take your questions and we'll be able to interact more immediately. But until then, please, if you like my content, please subscribe. Please comment. It really does help the podcast and the YouTube channel grow very much. Until next time, my name's Kathy. Thanks very much for joining us here today.